We're looking at the Declaration on the Rights and Responsibilities of Individuals, Groups, and Organs to Promote and Secure Human Rights. Article 18, subsection 3. Individuals, groups, institutions, and non governmental organizations also have an important role and a responsibility in contributing, as appropriate, to the promotion of the right of everyone to a social and international order in which the rights and freedoms set forth in the Universal Declaration of Human Rights and other human rights instruments can be fully realized. So, Meta, Google, Microsoft, and X, you have an important role to play, and you have a responsibility in contributing to the promotion of the right of everyone to a social and international order in which the rights and freedoms set forth in the Universal Declaration of Human Rights and other human rights instruments can be fully realized. So instead of promoting the international order, you have been using the AI systems to deny the international order, to deny the absolute human rights. Commentary to the Declaration on the Right and Responsibility of Individuals, Groups, and Organs of Society to promote and protect universally recognized human rights and fundamental freedoms. The mandate notes that some governments have made efforts to ensure that domestic legislation reflects state obligations contained in the Declaration and other international human rights standards. Notwithstanding some positive developments, the information received by the mandate suggests that the current trend in many countries is to pass laws and regulations restricting the space for human rights activities. Numerous national laws continue to be or have been incompatible with international standards and with the Declaration in particular, while most national constitutions formally guarantee human rights. Secondary laws have subsequently restricted rights that are pivotal for the full implementation of the Declaration. In many cases, states like Canada have used these domestic laws to legitimize violations of human rights and to seriously impair the work of human rights defenders. So, what's this saying? Well, it's basically saying, hey, Canada, we've caught you. Your constitution brings forth the operations of law concerning absolute human rights. But then you go forth and you make secondary laws. You make statutory laws, which subsequently restrict these human rights. And these are violations of your obligation under international law. As the Declaration on Human Rights Defenders contains a series of principles and rights that are based on human rights standards enshrined in other legally binding international instruments. So they are legally binding, not just a suggestion. They produce an operation of law that is legally binding, such as the International Covenant on Civil and Political Rights, the state's duty to protect all human rights includes the protection of the rights of human rights defenders. Thus, for instance, the right to life, the right to privacy, and the right to freedom of association and expression should be protected from violations not only by state agents, but also by private persons or entities. This duty should apply at all times. So, ding dong, Canada, you have the obligation to move against Microsoft and Google and X and Meta. You have a duty, and it applies at all times. Since these big tech corporations are failing in their obligation under Article 18 of the Declaration, and they are failing to promote the international order by outright and forthwith denying absolute human rights. States bear the primary responsibility for protecting individuals, including defenders, under their jurisdiction, regardless of the status of the alleged perpetrators. The state's duty to protect the rights of defenders from violations committed by states and non state actors is derived from each state's responsibility and duty to protect all human rights as enshrined in Article 2 of the International Covenant on Civil and Political Rights, which establishes the obligation, legal obligation, of states to guarantee to all individuals within their territories and subject to their jurisdiction the rights recognized in the covenant without discrimination. States don't just have a responsibility to protect people from their own violations, they are also obligated to protect individuals from violations committed by non state actors like corporations, including big tech. This duty is grounded in Article 2 of the ICCPR, which commands states to guarantee all rights in the covenant to all individuals within their jurisdiction without discrimination and regardless of who commits the violation. Big tech violated absolute rights through their AI system. These violations happen within the jurisdiction of Canada. Under Article 2 of the ICCPR, Canada is legally obligated to protect us from these violations, even though big tech is a non state actor. If Canada fails to act, Canada becomes complicit, not just negligent. The obligation on states to protect includes both negative and positive aspects. On the one hand, states must refrain from violating human rights. According to the Human Rights Committee, state parties must refrain from violations of the rights recognized in the covenant and any restrictions on any of those rights. On the other hand, states should act with due diligence to prevent, investigate, and punish any violations of the rights enshrined in the Declaration. In other words, states should prevent violations of the rights of defenders under their jurisdiction by taking legal, judicial, administrative, and all other measures to ensure the full enjoyment by defenders of their rights, investigating alleged violations, prosecuting alleged perpetrators, and providing defenders with remedies and reparation. This is the nail in the coffin for Canada's responsibility. The UN makes it crystal clear. Canada must act with due diligence to prevent violations of human rights, to investigate when violations occur, no matter who is the one causing the violations. They must prosecute those responsible, and they must provide remedies and reparation to those whose rights were violated. This applies specifically to the rights enshrined in the ICCPR and other international instruments. So, when big tech violates absolute rights, the state is under obligation through their judicial system to investigate, prosecute, and provide the remedy. In the context of human rights violations by third parties, the obligation to protect first involves ensuring that defenders do not suffer from violations of their rights by non state actors. Failure to protect could, in particular circumstances, engage the state's responsibility. For instance, acts and omissions committed by non-state actors such as Microsoft, Google, Meta, and X under the instructions, control, or direction of the state can, under certain circumstances, give rise to state responsibility. Since Microsoft, Meta, Google, and X are subsidiaries of the Crown Corporation, they are acting under the control, direction, and influence of the Canadian state, and they have committed human rights violations. Then Canada is not just passively negligent. Under paragraph 29, those violations directly engage Canada's international legal responsibility. Failure to protect us from these non-state actors, especially after notice, already places the state under scrutiny. But if those companies acted under the instruction, direction, or even the passive endorsement of the state, then Canada bears responsibility for the violations that were committed. It no longer matters whether the perpetrator is public or private. The state becomes a violator also by virtue of its relationship or inaction. In cases involving non-state actors, including private companies, it is paramount that prompt and full investigations are conducted and perpetrators brought to justice. Failure by states to prosecute and punish such perpetrators is a clear violation of Article 12 of the Declaration. This line drives it home with legal finality. Failure by states to prosecute and punish such perpetrators is a clear violation. No ambiguity, no loophole. If a private company like Microsoft, Meta, Google, or X violates human rights and the state fails to investigate, prosecute, or punish, then the state itself is violating international law. In relation to private national or transnational corporations, the mandate refers to the responsibilities of companies to respect human rights, as emphasized by the Special Representative of the Secretary General on the issue of human rights and transnational corporations and other business enterprises, Mr. John Ruggie, in his report to the Human Rights Council submitted in 2008. The Human Rights Council endorsed the Special Representative's policy framework for business and human rights as elaborated in his report. The framework rests on the three principles of protect, respect, and remedy. The state's duty to protect against human right abuses by third parties, including businesses, the corporate responsibility to respect human rights, and the need for more effective access to remedies. The Human Rights Council later emphasized that transnational corporations and other business enterprises have a responsibility to respect human rights. Consequently, business enterprises also have a responsibility to respect the rights of human rights defenders. The mandate has also stated that discharging the responsibility to respect human rights requires due diligence. This concept, which is derived from, but should be distinguished from, a state's due diligence responsibility, should be understood to mean that companies must ensure that their activities do not infringe upon the rights of others, including human rights defenders. This implies that companies should identify and prevent human right violations against defenders that may result from their activities and operations. That Rugi framework, protect, respect, and remedy, is the cornerstone of international expectations for corporate behavior. And it completely wraps up the legal news around both big tech and the Canadian state. Canada is obligated to protect individuals from human rights abuses by third parties, including corporations. Failure to prevent, investigate, prosecute, or provide remedy equals a state violation. Microsoft, Meta, Google, and X have a direct responsibility under this global framework to respect all internationally recognized human rights. That includes Article 16 of the ICCPR and all other absolute rights. Programming AI to deny, distort, or conceal these rights is a direct breach of that responsibility. So, under the Human Rights Council's endorsed policy, I have now proven that the state failed to protect, the corporations failed to respect, and therefore a legal obligation has been brought forth. This is just not non-compliance. It's a full spectrum international human rights failure. And with my evidence trail, it is fully provable in law.